On October 6, 2022, an entire team of law enforcement officers descended at the Mine Beer factory in Carmelita Village, Orange Walk, on the strength of a warrant directed to Inspector Gian Young. During that search, law enforcement seized a whopping $3.1 million. This has caused a hiccup at the Caribbean International Brewery Company Limited, and before the weekend, senior counsel and the former Prime Minister of Belize was hired to represent the company at the Orange Walk Magistrates Court to fight their case, which is to have the Financial Intelligence Unit return their $3.1 million in cash because they believe that the authorities illegally seized the monies. The FIU, on the other hand, intends to keep the cash until they have completed their investigation as to how the money was generated. That case began at the Orange Walk Magistrates Court on Friday before Magistrate Deborah Rogers and resumed today. But this time the FIU lawyered up and arrived in court accompanied by former Attorney General and senior counsel Godfrey Smith. After listening to several testimonies, the court took a break, and that is when the media got an update from Barrow.
There are procedural objections that remain live. I had made some preliminary submissions to the magistrate, and she did not accede to my submissions. But as the evidence develops, certain things are becoming so clear that I will have a second go at this particular point. The application is being brought by the FIU pursuant to Section 38 of the Money Laundering Act. That section makes clear that where a police officer or a customs officer is lawfully on premises and sees money and has a reasonable suspicion that the money may be proceeds of crime, may be tainted, may be laundered, the policeman is able to seize the money based on that reasonable suspicion, hold it for 72 hours, and thereafter to come to court with an application for continued detention. The policeman who did the seizure, or the police authorities that did the seizure. The warrant was to Inspector Jan Young, and you heard him concede that he did the seizure. He did the seizure of the first amount of cash at 8. He did the seizure sometime after 8, and the seizure of the second amount of cash sometime after 9. Two things. The original application for the continued detention, brought in the name of the FIU, wrongly as far as I'm concerned. It is the person who seized upon a reasonable suspicion and who is continuing to investigate that can come to ask for continued detention.
And as mentioned, the company is sticking to their story. That is, that multi-agency team of law enforcement officers seized their funds last week during the 2-day raid unlawfully.
The application wrongly filed by the FIU was filed at 4:29 p.m. on last Wednesday. The seizure had taken place, as we know here, not later than 9 a.m. on the previous Thursday. 72 hours had already elapsed, and so the continued detention by the police/FIU of the money was unlawful.
So you're saying that right now your clients should have their money?
Absolutely. Absolutely. And there is nothing in my submission that can be led to defeat their right. As you say, looking at the merits, there's no causal connection. The inspector admits he did not have any suspicion of money laundering. He thought the proceeds were derived from 14 Chinese being trafficked. There's nothing to show that these people are being trafficked in any way. But that apart, what the application said, was that this was money that was seized by the police, then re-seized by the FIU. Which re-seizure by the FIU? It was always the one seizure by the inspector who sent for the FIU and afterwards gave them custody of the money. But it is his seizure, there is no re-seizure. So the FIU is completely without any remit to bring this application. And even if that is not so, you can't bring it more than 72 hours after. You can't hold the cash for more than 72 hours. They tried to get around it by suggesting, well, the FIU re-seized when it was handed custody at 9 the night, which would perhaps bring the... No, you heard I was the one who seized, and I seized at 8 and 9 a.m. Right. So they're completely, as far as I'm concerned, clean bowled.
While Barrow is confident that he has a winning case, the longer the FIU withholds the companies with $3.1 million, his client's business is in jeopardy.
What they said to me was that they will have to borrow money and pay whatever interest whoever will lend them the money charges so that they can continue. Because I've told them that in order to do justice to the matter, we can't expect, you've heard the magistrate, even if we finish with the case proper on Wednesday, she won't give a decision until maybe a week after. And I'm not even certain that we are going to finish on Wednesday. So if they wait for the money to be returned in order to continue with their business, they're going to be in really bad shape. They will no doubt get back whatever losses once we win, either here or in the Supreme Court. But that's after the fact. So they are trying to make arrangements to continue, not to have the business closed down while they await the decision here and possibly in the Supreme Court, if depending on what the magistrate does or does not do.
As mentioned at the top of the newscast, the FIU found it necessary to hire one of the big shots in law, senior counsel Godfrey Smith, to represent them in this case. He now goes head-to-head with attorney Dean Barrow. While Barrow has argued that the $3.1 million seized from Caribbean International Brewery Company Limited must be returned, Smith is saying it must remain under lockdown.
I think there is a misunderstanding of what the nature of this case is. This case is not proof or innocence of money laundering or any other crime. This case is simply an application to hold on to seized cash for 3 months pending investigation. What is the test? What must the applicant satisfy the magistrate of? Simply that there is reasonable suspicion that the cash is related to a criminal offense. It doesn't say which criminal offense. So if you look at Section 38 of the Act under which the application is made, it says you must satisfy the magistrate that when you seize the cash or when you seek to detain it, that it is based on a reasonable suspicion of the commission of an offense. Reasonable suspicion simply means that the officer or the team who did the seizure must have some grounds. It doesn't have to amount to proof. So what you would have heard were arguments and submissions about proof and evidence, when that all that is required is suspicion. But the suspicion can't be fanciful or imaginary or whimsical. It must be based on some factual circumstances. We are satisfied, as I said, that the seizure was lawful and that there is grounds for the magistrate to rule that the money ought to be detained for 3 further months pending investigation. I noted that in earlier public communication on this matter, the Caribbean Brewery International mentioned that the reason for the stash of cash was because the banks would not allow for more than 50,000, and any deposits of more than 50,000. And obviously, we would have gotten information through the FIU that, in fact, that is not the case. As you are aware, the FIU has certain powers to request banking information and so on. And so we intend, as this case develops, to demonstrate that that is a complete untruth. It's a complete lie.
We will keep following this story and bring you all the updates when the application goes back to court on Wednesday.